It is July 18th, disregard that. And, when we talk about employment issues in church, one of the things that we're concerned about is that it takes a lot of employees sometimes to get do church correctly. And sometimes the staffs of churches have become quite large, and these employment issues can be varied, and there are lots of challenges from payroll to overtime hours, minimum wage, and things like that. So I'm going to go through a number of the challenges that we see from an employment law perspective as lawyers here at the Carpenter Law Firm. And here in Arizona, I'm going to run through these here in about no more than 59 minutes, like a sermon that doesn't run over time. I'm going to keep this to a minimum here today in a bring your own lunch Zoom webinar format. So the first one we deal with is, how do you characterize your employees? Are they W-2 or, as we sometimes say, 1099? Now, one thing we'll say for certain is that across all industries, anybody who has workers for pay, anybody who engages a worker would prefer to pay them as a 1099. Now, when I say 1099, this is the tax form that the employer pays, provides to the engaged worker at the end of the year, if the person is a independent contractor. If the person is an employee, they get a W-2. Now, most people know this, and the worker would prefer to get a W-2 because a W-2 worker has their wages and taxes paid by the employer as a W-2. If you're a 1099 worker, you have to withhold and pay your own taxes on a quarterly basis, and you have to pay your own Social Security and Medicare withholding. If you're the worker, basically it's a major pain to be an independent contractor versus a W-2 employee. But if you're the employer, it's easier. If somebody's going to make $10,000, just pay them the $10,000 and give them a W-2, give them a 1099 at the end of the year. If you're going to pay someone $10,000 as an employee, you have to do wage withholding. We know this. And so characterizing someone properly as an employee versus an independent contractor is a somewhat complicated test. The IRS prefers that people be characterized as an employee because taxes are withheld and the government gets its taxes earlier, gets it on a quarterly basis, and that's the preference. So we'll concede that employers would rather pay its workers as a 1099, and churches are the same. A contract drummer or musician, a gig musician who brings his or her own instrument is usually going to be an independent contractor. There's no question about this. An outside consultant, a graphics person or a website guru with their own computer, that works. Anybody who brings their own equipment and has other clients is going to be an independent contractor. A musician who brings his or her own instrument and does music on an itinerant basis for 10 churches, but they just happen to play bass at church XYZ, and they do it for 10 churches, and that's just their gig thing that they do. And over the course of a year they make $5,000 from your church. They get a 1099 because they bring their own bass, and they just happen to do it for the youth event once a month on Wednesdays. That's a 1099, and they get paid to do it, no question. the person who does your graphics or website work, and they bring their own computer, they bring their MacBook, and you don't supervise how they do it or the hours that they do it, that's an independent contractor. There's no question about it. There are three things the IRS looks at. The first one is behavioral control. From the IRS regulations, this refers to facts that show whether there is a right to direct or control how the worker does the work. The church is not directing how the bassist plays the bass. This worker is an employee when the business has the right to direct and control the worker. You're not telling the website person how to code the website per se. The business does not have to direct or control the way the work is done if the employer has the right to direct and control the work. The second broad category is financial control. Financial control refers to facts that show whether or not the business has the right to control the economic aspects of the worker's job. And then the third piece is the type of relationship. This refers to facts that show how the worker and the business perceive their relationship to each other. Now, many businesses think this is the only part of the relationship that matters. These factors generally fall into the category of written contracts. So many businesses, and not just church businesses, or church enterprises, I should say, think, well, we'll just enter into an independent contractor agreement. We'll just agree that our relationship is an independent contractor, and that'll solve the entire problem. So-and-so used to be an employee, and we'll switch it over to independent contractor, and we'll enter into an agreement. We'll put it in writing, and that'll solve the entire problem. Then we won't have to do any wage withholding. We won't have to pay overtime. We won't have to pay Social Security and Medicare withholding because the employee will agree that he or she is an independent contractor, and that'll solve the whole problem. That will make the person an independent contractor. But as you can see here, it's one factor in the third of three component inquiries type of relationship, whether there are employee benefits, the permanency of the relationship. If it's temporary, it feels more independent contractor-ish, but not necessarily. And then the services provided, as if it's a key activity of the business, it feels more like an employee. And so that's the third part of the inquiry. All right, I want to also talk about some U.S. Supreme Court cases in the area of church law, church employment law. There are two of them that we talk about all the time. The first one is called Hosanna Tabor. And of course, as you know, when we talk about U.S. Supreme Court cases, we talk about them based on the name of the litigants. And Hosanna Tabor is an important case, as well as Our Lady of Guadalupe. Now, these two cases involve teachers in separate lawsuits that alleged employment discrimination in churches and church-related schools. They were not ordained ministers, but they taught religion classes. Arizona is in what we call the Ninth Circuit of the federal court system. And these cases ruled against the schools. The U.S. Supreme Court agreed with the schools that the teachers could not sue for their employment discrimination against the churches and the schools. Now, the U.S. Supreme Court in the year 2020, which seems like yesterday in a sense, now we're 4 years out, And what they said was whether a religious institution could, whether the religious institution calls an employee a minister is not, standing alone, dispositive, particularly because some faiths don't use that title or have formal organizational hierarchies. And the reason this is important is because the case created something called the ministerial exception. And the ministerial exception basically said ministers do not have employment related discrimination claims that they can assert in court. And the court said that academic training may be important, but the absence of formal theological training is not necessarily a deal breaker. What matters is what an employee does in their job. So the bottom line is the Supreme Court said that ministers cannot sue churches or religious schools for employment discrimination. It's a very important case if you're a church. Not a great case if you are on the receiving end of employment discrimination, if you're employed by a church. So it was very troubling in the legal world for people who believe that churches are discriminating in employment constantly against people who are in protected categories. People based on gender, national origin, sex, sexual orientation, things like that, race. But the ministerial exception has created a lot of discussion among lawyers and people who are advocates for people in these protected classifications. And of course, churches employ a lot of people across the country. And so we have what we call the ministerial exception that says ministers cannot sue for employment discrimination. So it raised the question. We've discussed this some at seminars that I've done over the years since these cases came out. The somewhat abstract question, and we say it with a smile on our faces because we're joking. The rhetorical question, maybe everybody's a minister. The minister of first impressions for the receptionist, the minister of landscaping, the minister of the parking lot. And I'm joking. This would be ridiculous. I think the courts would see through it because even though I just said that the court said academic training may be important and the absence of formal theological training is not necessarily a deal breaker, the fact that the person you hire to be the receptionist doesn't have any formal theological training is not necessarily a deal breaker. What matters is what an employee does. If the employee is answering the phones, but the court, in these cases, what the court noted is that in the Hosanna Tabor case, the teacher was teaching religious classes in her private school. The receptionist is simply answering the phone or greeting people as they arrive on the campus. There's no religious instruction in answering the phone and saying, First Baptist, you want to talk to the pastor? Okay, routing the calls or greeting people when they come in for their appointments. There's no religious component to doing that. At a law firm, when the receptionist answers the phone and routes calls to 30 attorneys or greets people and shows them to the conference room, there's no legal training involved in that. There's no legal component in that job. And if we say that the receptionist at a law firm answering the phone and routing calls to 30 attorneys or greeting people and showing them to the conference room is the functional equivalent of the receptionist at a church with a 30-person staff and conference rooms, the equivalent is there's no theological component to that, just like there's no legal training or legal component to that for the receptionist in a law firm. I couldn't make the argument that there's any legal component to the receptionist in a law firm, just like I don't think we could make the argument with a straight face that there's any religious component to the receptionist doing that in a church. And same thing with the landscaping. So it's a rhetorical, tongue-in-cheek point here that you cannot say that every employee is a minister. So although we have the ministerial exception that ministers cannot sue for employment discrimination, it's a tongue-in-cheek rhetorical notion that many of your employees could be ministers. Now, many of your employees are ministers because they have at their core what matters at bottom is what an employee does. Many of your staff are ministering to people. And a court could find that their core function is ministerial. And without the word minister in their job title, as the second bullet point points out, this is from the Supreme Court's decisions. You don't have to use the word minister. Some faiths don't use that title. And many evangelical traditions don't use the word minister, pastor, and don't even have to use the word pastor. It's whether or not in the organization of the church, whether someone is doing church ministry. And that's the important question as to whether or not the ministerial exception applies. So we're not going to give people titles to try to shoehorn them into the ministerial exception. There are 4 factors, but no rigid formula. Let's go through them. Whether the employer, that's the church, held the employee out as a minister by bestowing a formal religious title. It could be pastor, could be minister, it could be I'm going to make a joke. It could be grand poobah. Could be whatever word is used in that tradition to signal minister or top person within the order. Whether the employee's title reflects ministerial substance and training. Whether the employee held herself out as a minister, and whether the employee's job duties included important religious functions. That's where we get potentially held up with this shoehorning or trying to push people into the ministerial exception that don't belong there. The landscaping, the receptionist, the cleaning the bathrooms, that's not an important religious function. Doing the custodial work, the landscaping, the receptionist. And I'm not putting those jobs down. Those are important functions for a well-run church, but those are not important religious functions. I mean, you could try to make the argument that the whole operation can't run smoothly for everyone to have a good experience in the house of the Lord if those things are not done well, but it's a bit attenuated. It's not really going to work because the 4 factors don't work altogether when we talk about those jobs. Okay, so if the ministerial exception is the way to avoid discrimination claims, then it becomes true then that non-ministers can sue for employment discrimination, including wage claims, discrimination in employment. It could be, I've been discriminated against because I'm paid less than a man. It could be wage and hour claims, overtime claims, any a number of things like that. So we have, I'm discriminated against because of my race, uh, all manner of discrimination claims. All right, let's talk about a couple of other concepts in employment. Let's talk about internships and volunteers. A few years ago, the Department of Labor, the Federal Department of Labor, in 2018, this may seem surprising, in the middle of the Trump administration, decided to clamp down on unpaid internships in the for-profit environment. When people were saying, well, I have an internship at a Fortune 500 company, and college students would graduate from college and say, well, I have an internship, but it's unpaid. That ended because the Department of Labor decided that this was not appropriate, that companies should not have unpaid labor from college students, and there are no more legal unpaid internships in the for-profit environment. But the Department of Labor regulation that prohibits unpaid internships in the for-profit environment is very clear that it is prohibited in the for-profit environment. But we also know that you can have an internship in the nonprofit environment. So the general rule is, and we know this intuitively, that churches do not have to pay volunteers. Of course, you can have volunteers. I mean, that's sort of part of American life, is that people can always volunteer. So we can have volunteers providing services without any expectation of compensation and without any coercion or intimidation. These are not employees. We call these non-employees. So what are the volunteer factors? Is the worker motivated by a personal, civic, humanitarian, charitable, religious, or public service motive? And this is actually a part of the law. And there's no problem at all with this. Are the services performed typically associated with volunteer work? If the answer is yes, then we have no problem. So we encourage, of course, from a legal standpoint, internships are absolutely great and an important part of a well-functioning and a high-functioning church. And they're an important part of how people become involved and part of the church body. What's important sometimes is that, so that there's no confusion, that we get an intern to acknowledge this is a volunteer internship. I'm not going to be paid, and I know that, because there has become an increasing expectation that internships are paid. Not sure when it happened. Maybe it started happening when in 2018, so many internships in the for-profit sphere became paid. Perhaps many college kids, friends started getting paid internships in the for-profit realm, that people started to expect that, well, I'm getting an internship at my church or at this mission organization. I want to get paid. I'm going to spend the summer on an internship in Spain or Mexico or whatever, that people wanted to start getting paid for it. And maybe not expecting to be paid a lot of money necessarily, but people do increasingly want to be paid, and having clear expectations up front is often necessary. And we need to have a clear understanding of exactly what is involved with the internship. So let's make sure we know what the Department of Labor did exactly. So here's exactly what they did. In 2018, the Department of Labor said an unpaid internship is permissible, but only under these conditions. So a for-profit company can do an unpaid internship, but the unpaid internship can be done if the intern and the employer clearly understand that there's no expectation of compensation. And the internship provides training that would be similar to that which would be given in an educational environment. And then the extent to which the internship is tied to the intern's formal education program, and there has to be integrated coursework or the receipt of academic credit, and the internship accommodates the intern's academic commitments by corresponding to the academic calendar, and the internship's duration is limited to the period in which the internship provides the intern with beneficial learning, and the intern's work complements rather than displaces the work of paid employees while providing significant educational benefits to the intern. When the Department of Labor said basically, hey, employer, you can do an unpaid internship, but you basically have to make it academic. You have to basically be a college course at the office. Most employers said, you've got to be kidding me. And as a law firm, I kind of looked at it and I said, no way. Because I've had a lot of clients over the years say, hey, I've got a kid who'd like to do an internship at your law firm. And I never wanted an intern to work free. I'd rather pay, because I don't want the guilt of having free labor. So it never made any sense to me to have a free worker. It felt exploitive anyway. It never felt right for me in my conscience to do that, because I never really thought that a law firm provided enough value to the person that they were getting more out of it than I was providing. But so never had an unpaid intern. But when this came out, and I thought, look, if you look at these bullet points and you say, well, why would a company, even a Fortune 500 company, let's call it Google or Amazon, that's a lot of work right there. That's a tremendous amount of work. Maybe even Amazon. You say, well, why would they do that? Why would they create Amazon University to complement some kid from ASU to get free labor out of the kid for 9 months while the person works free at Amazon? That's a tremendous amount of work. I mean, now Amazon is paying someone to develop this unpaid internship program that is basically a full-on university class within Amazon, so that this employee unpaid intern at Amazon can get credit at ASU, all in return for Amazon to get free labor out of this intern. So they're paying this Amazon employee, let's just say, let's make up a number, $125,000 a year to develop this unpaid internship program to get free labor out of this college kid who's returning value to Amazon in far less than the $125,000 they're paying to the employee to develop the program to get the free labor. You see how it doesn't make a lot of sense economically, and that's why there aren't very many unpaid internship programs out there anymore, and why companies basically said, we'll just pay the interns, because the economics didn't actually make any sense. For the 125,000, I'm making these numbers up, please. I'm just making them up out of thin air. For the 125,000, it would cost to hire the skilled person to develop the unpaid internship program. They could probably hire 4 or 5 paid interns at Amazon for that period of time. So you could tell I'm cynical about it, but churches don't actually have to worry about it because all of these requirements apply to for-profit enterprises. So we're not too concerned about it. As I said in the previous slide, we can have volunteers, we can craft these. What I'm concerned about mostly is an acknowledgement at the front end. I'm volunteering for the summer, it's an internship. I'm the worship leader intern, I'm the youth leader intern. It's for the fall of 2024, it's for the spring of 2025. I understand I'm not getting paid. These are the expectations. I'm going to get a review at the end. I may get a recommendation from the senior pastor at the end. All of these acknowledgements up front. I'm expected to be here every Wednesday night. I'm expected to lead youth activities Fridays, whatever the expectations are. And then when the review is done at the end, the reviewer can say, you acknowledge that at the beginning, you're expected to be here every Wednesday. You missed 4 of those. That reflects negatively on your commitment, and there won't be any surprises. And just everybody knows up front. All right, let's talk a minute about a minimum wage. In Arizona, the 2024 minimum wage is $14.35 an hour. And unless you're a minister, there are people who could make wage claims. That's $574 a week on a 40-hour week. That's $29,848 per year. And courts have ruled that ministers cannot assert wage claims. So non-ministers can assert wage claims, and not just the minimum wage, but overtime claims as well. The non-ministers can assert overtime claims and violations of the minimum wage. So these are some of the things that matter at church work here in Arizona. It's not an invitation to underpay ministers. The market dictates salaries and compensation. If people are not adequately paid, then they'll presumably go somewhere else. I believe the market decides. A couple of other quirky things happen every once in a while. Every once in a while, we see people with mandated tithing and mandated volunteering in churches. Every once in a while, a church might say, well, employees here are required to donate back, it's deducted from your paycheck, a portion of your salary, a mandated tithing, you might say. And that rule that requires employees to donate back does not violate any law or statute. And it would be nice if the church were to have the employee sign a consent, or the employee were to um, do it voluntarily. But if it's in an employee handbook, at least at a minimum, it would be better than it just simply happening automatically. And then see this sometimes, rules that require employees to volunteer hours, or a rule to attend the church that employs him or her. Those rules do not violate any law or statute here in Arizona. So this comes up every once in a while, and I get questions about it now and then. Again, no problem. The result under the law would be the employee can remain employed or find a different job. It's pretty simple. I mean, to be weird about it, but those are the options. You can stay employed there, or you can find a different job, go to a different church. So the lawsuit, if the employee is a minister, could be dismissed because the church could say, well, ministerial exception, there's no claim. If it's not dismissed, the person could say, well, it's uncompensated time. It's a straight wage and hour claim for hourly employees that are asked to volunteer. If it's as far as the volunteer part, that it was uncompensated time. And but if the person's a minister, they would say, well, I was forced to volunteer, I wasn't paid for that, but that's a wage and hour claim. And the church would say ministerial exception. But if the person's not a minister, the volunteer time, that would be a wage and hour claim. So there's potentially some risk there that they should get paid for the mandatory volunteer time. So it's not completely without risk that a non-minister employee could say, I should get paid for that because I'm hourly. On the mandated tithing part, somebody could sue to try to get a refund of that. That would be an argument that somebody could make. But we don't see very many lawsuits like that. And I'm aware of these policies existing. The fact that we don't see very many of these lawsuits suggests that people aren't that troubled by them. So, but it is possible that somebody could file a claim and sue to get their cumulative forced contributions back. But as I said, there's no law or statute that says it can't be done. But I did say that it'd be nice for someone to just voluntarily consent to the withholding of their 10%, whatever the number is. All right, one more thing that I always like to mention when I do these seminars is Arizona's duty to report abuse. Before I finish here, this is a flow chart. It's been improved into a different format in a laminated form, but I don't have this form for my PowerPoint. It's a statutory matrix in Arizona for clergy. We're using the word minister throughout the employment discussion, but in the duty to report, we use the word clergy. Basically, the words mean the same thing. The first question is, do you reasonably believe that a minor is or has been a victim of a reportable offense? Now, we already have two words, two phrases that we don't know what they mean. The first one is, do you reasonably believe that a minor is or has been a victim of a reportable offense? Reasonably believe. What does that mean? Do you believe it? Do you believe that a minor has been a victim of a reportable offense? What is a reportable offense? Well, it's everything you think it could be. It's sexual abuse. It's rape. It's somebody being not cared for. It's being abused. It's being left in a hot car. It's a foster parent leaving a kid alone. It's a child being hit. It's being a child being exposed to pornography. It's every bad thing, every single solitary bad thing that could happen to a kid, every single one. Do you believe, and is that belief reasonable, that a minor is or has been a victim of a reportable offense? If you don't believe that, then the answer is no, no duty to report. If you do believe it, are you a member of the clergy or priest or person who has responsibility for the care or treatment of a minor? That's the tricky part right there. If you're a member of the clergy, then you answer yes. You go to question 3. If you're a member of the clergy and your entire basis for your reasonable belief is a confession, and you determine that it is a reasonable and necessary within the concepts of your religion to withhold the confession, then you say no. And then we keep going. But let's stop there for a second. I don't work with very many Catholic congregations, Catholic priests. The way that's worded, it was really drafted by the Catholic lobby. I don't believe I have very many folks from the Catholic tradition on the webinar today. And as it turns out, most of the church folks I work with in my law practice, the way this is worded, it's very rarely true that in the evangelical tradition, that confession, it is necessary within the concepts of the religion to withhold the confession. It's not part of the evangelical tradition. And so if you are aware of your reasonable belief because someone comes to you and confesses, at that point, within the evangelical tradition, it would not be the case theologically to withhold the confession within the traditional theological concepts of the religion, to withhold it from the authorities, to protect the confessor. So we wouldn't actually go to number 2. But if it is, then you say no. Is your reasonable belief regarding sexual abuse or sexual conduct with a minor where both minors are 14, 15, 16, or 17, and there's nothing to indicate the conduct is not consensual? So there's this consensual sexual contact exception. where the minors are 14, 15, 16, or 17, and then you say no, no duty to report. No, you say if no, there's a duty to report. If yes, no duty to report. I'm sorry, if no, there is a duty to report. Is your entire belief regarding sexual abuse or sexual conduct with a minor, where both minors are 14, I got confused there for a second, are 14, 15, 16, or 17, and there's nothing to indicate the conduct is not consensual? If yes, there's no duty to report. If no, there is a duty to report. So I bring this up because it comes up all the time, and I wanted to provide it as a reminder. I have some extra copies of this laminated duty to report. We like to provide these at no cost, of course, to our church clients and friends. And so if you'd like a copy of this or several copies for your church leaders, we'd be happy to mail it out. And I have the contact information for that. Happy to send a PDF of this PowerPoint and this duty to report flow chart, which is in a slightly different format than the flow chart on that previous slide. Just send an email to info@carpenter.law. My law partner is Nick. And you can contact me at scott@carpenter.law. I'll take questions in the chat if you have any. And you can contact me anytime here. If there aren't any, happy to end a few minutes early. Like a sermon that ends on time. Well, thank you all for joining me today. Hope you enjoyed this. I'll do another seminar next month. And hope you all have a great rest of your day. Thanks.